This is Barry's Alma speaking for Claim School Incorporated's blogs, Alma on Insurance. Today we're going to speak about why an appraisal award sets the amount of loss, and once it's signed, it should be enough, and why dispute over the extent of damages is simply not bad faith, it's just a disagreement over an amount. And an award signed by 2 of 3 appraisers is binding on both the insured and the insurer. Kelly Mallady filed a lawsuit against Homeowners of America Insurance Company due to damages sustained from a nearby explosion in January of 2020 that the insurer rejected in part. In a case entitled Kelly Mallady versus Homeowners of America Insurance Company, the Court of Appeals of Texas on August 7, 2029, resolved the disputes. The case was about Mallady's homeowners insurance policy that was effective from September 15, 2019 to 2020. The initial claim was acknowledged that an independent adjuster estimated property damage to be $13,014.79, covering only the dwelling and the fence. Mallady invoked appraisal demanding $247,860.40 for property and contents damage plus $10,000 in attorney's fees. The first appraisal award, in April, set the loss for the dwelling at $24,000 replacement cost and $21,900 actual cash value. The April award did not address contents damages and was later voided by the trial court. A subsequent appraisal award, the June award, assessed damages at $215,616.65 and $145,778.70 actual cash value, covering the dwelling, fence, and contents. Homeowners of America filed a motion to set aside the June award and confirm the April award, arguing the April award was binding once signed by the 2 appraisers. The trial court set aside the June award and confirmed the April award. Mallady filed suit alleging breach of contract, bad faith, deceptive trade practices, and other claims, and the trial court granted summary judgment in favor of Homeowners of America, which Mallady appealed. The appellate court affirmed in part and reversed and remanded in part. The court concluded that the trial court erred in granting summary judgment on Mallady's breach of contract claim, and the court sustained several of Mallady's issues challenging the trial court's grant of summary judgment. First, the court dealt with the breach of contract claim, and that the court concluded that the trial court erred in granting summary judgment on Mallady's breach of contract claim. The April award did not set the amount of loss for contents, and the evidence showed that content damages were to be addressed in a separate award after inspection of the property, and therefore the trial court's decision to grant summary judgment was incorrect, as there was a genuine issue of material fact regarding the contents damages. The award, which assessed damages only for the dwelling, was signed by 2 of the 3 parties, making it binding. However, the June award, which included damages for dwelling, fence, and contents, was issued later and signed by 2 appraisers. The trial court set aside the June award and confirmed the April award, but the appellate court found that the trial court erred in that decision. Although appraisal clauses stop a party from contesting the issue of damages in a lawsuit based on an insurance contract, if a party seeks to avoid an appraisal award, the burden of proof is theirs to raise an issue of material fact as to why the resolution they contractually agreed to should be set aside. If the appraisal award is not set aside, the contractual process settles the issues of damages and settlement of the full amount owed, as stops the insured from bringing a breach of contract claim against the insurer. The trial court's order requiring Choate, the appraiser, to submit to an examination under oath was vacated because the court concluded that the policy did not require Choate to submit to an examination under oath, as he was not considered Mallady's representative. However, since Choate, as an independent appraiser, is not a representative of the insured, he may not be compelled to testify at EUO. Mallady's claim for mental anguish and attorney's fees were not considered independent injuries that could support her extra-contractual claims. The court found that the mental anguish damages stemmed from denial of policy benefits and were not truly independent injuries. In my opinion, once an appraisal award becomes final, signed by 2 of the 3 appraisers, the amount of loss is established. When there is a second appraisal making findings of loss and damages more than $200,000 greater than the first and final award, the original award must be honored. However, since the first award failed to consider contents damage, it was incomplete, and another appraisal or trial of contents was required. The breach of contract can be tried, but the bad faith case was eliminated. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. If you do, you can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll also gain access to the more than 5,150 blog postings. Please tell your friends and colleagues about this blog so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publications. Thank you for your attention.